Hi, and welcome to this overview of the SRA's COLP and COFA requirements. Since 2012, every law firm regulated by the SRA has had to appoint two compliance officers: a compliance officer for legal practice, or COLP, and a compliance officer for finance and administration, or COFA. All firms have to have both, though one can take on both roles if they're feeling particularly brave. Okay, so today I'm going to be talking you through the key COLP and COFA requirements and also some practical steps which you as a compliance officer or perhaps as a firm can take to ensure success in these roles. There's also a free book available on our website which goes into a lot more detail. Note that in-house lawyers do not need a COLP or COFA for the moment. Okay, finally, just before we get stuck in, do please also check the terms for using these training sessions on our website. Note in particular date of this talk, July 2014. Depending upon you watch it, it might obviously be out of date. And the things that we talk through today, they're just in general in nature only. Okay, so let's start. Excuse me. Okay. So let's start with looking at what a compliance officer is, just briefly. Well, if you're a compliance officer, you might sometimes feel a little bit like an SRA volunteer, just perhaps without the voluntary bit, maybe. Compliance officer has duties along the lines of what you might expect the SRA to do if it had the resources or desire to be in all firms at all times. Their role basically is to promote, champion, and monitor compliance with the SRA requirements. We're going to look at these duties in much more detail later on in the talk, but essentially the COLP and the COFA have three jobs to do. Firstly, they're there to promote and facilitate compliance in the firm, so to help the firm and the staff comply with SRA requirements. Secondly, they must record any failures to meet the SRA standards. And we assume that therefore means some monitoring as well and systems for having things reported to them. And then finally, they must report certain compliance breaches to the SRA. Not all, but essentially the more serious issues. As I said, we're going to look at that in much more detail later on in the talk, but hopefully that sets the scene reasonably well from here. Okay, so let's start to look at these roles in a little bit more detail, and let's start with the COFA. There is a division of labour between the COLP and COFA roles. The rules envisage them having separate responsibility for separate parts of the SRA requirements. In terms of the COFA, it's a fairly simple story. Primarily, it is all about compliance with the accounts rules. Obviously, as most people will know, the accounts rules set out fairly detailed requirements about how client money needs to be handled. But they also now require compliance with the SRA principles and some other rules and regulations. So particularly talking about the principles and the Code of Conduct, Chapter 7, as far as Chapter 7 relates to effective financial management of the firm. So it's not just about facilitating and monitoring compliance with perhaps the rules on record keeping for accounts. COFA would also be expected to report to the SRA serious concerns about the financial standing of the firm, if it was in financial peril, for example. Just quickly mention, whenever I talk today about SRA accounts rules, SRA principles, code of conduct, etc., I'm talking about a particular part of the SRA handbook, which you can find and reference free of charge on the SRA website, www.sra.org.uk/handbook. Sorry, as we'll go on to see, there is a bit of overlap because, as I was saying, the COFA, it's not just the accounts rules now, because the accounts rules require compliance with some other parts of the handbook. So we'll see that overlap in a little bit more detail now as we go on to look at the COLP. Now, in contrast, the COLP's responsibilities are about as broad in terms of facilitating and monitoring compliance as they could get. The kitchen sink wouldn't look out of place on the COLP's list of responsibilities. It is as wide as it gets. So let's break it down in a little bit more detail though. Rule 8.5 of the SRA authorisation rules specifies that the COLP has 3 areas of responsibility. So taking the first one then, the COLP needs to take certain steps to facilitate compliance with the SRA, with what the SRA calls the terms of the firm's authorisation. This basically means that the firm and its staff should only be providing legal services which they're authorised by the SRA to offer to the public. So if, for example, you've got an unqualified paralegal and they just tell you about their advocacy they've just been doing in the Supreme Court, Court of Appeal, whatever it is, you know you've got a problem. Okay, so a lot of it is about the reserved legal activities, which is, tricky, but the COLP should be clear what reserved legal activities. Most law firms will have a fairly comprehensive suite, except for advocacy, obviously, at certain levels. But they need to understand that, and they need to understand, for example, if there's a conveyancing department, what the particular risks are there, or a litigation department, in terms of any unqualified staff doing the work. So that needs to be borne in mind. Terms of the authorisation, so what the firm can and can't do. Okay. Secondly, the COLP needs to take certain steps to facilitate and monitor compliance with the conditions of the firm's authorisation. Now, conditions on your authorisation used to be where there'd been a particular problem, something had gone wrong, but since 2012, every law firm has had some standard conditions put on them. They're set out in Rules 7 and 8 of the SRA authorisation rules, and if you're not familiar with them, I would recommend having a look, or at least looking at the summary that we provide in our SRA handbook checklist on the website. Our website, www.complianceoffice.co.uk. So you'll see from the summary or from the rules, there's quite a few obligations in there that you perhaps might have expected to see in the Code of Conduct, but that's where they are. There is conditions on the firm. So things like the requirement to inform the SRA if you're planning on taking on a new partner. That you need the approval first, generally. That's where that comes from. Also includes a fairly onerous duty, I think it's probably fair to say, pardon me, on partners and firms to ensure compliance with all legal and regulatory requirements and to have suitable systems and arrangements in place to achieve this. As we'll see later on, the duty to actually ensure compliance then on the part of the firm and the partners, that's even more onerous than the COLPs and COFA's duties. COLP and COFA have to take some specific steps that we'll be looking at, but if they do that, they're not responsible for what goes wrong. Okay, they don't take on vicarious liability for other people's wrongs. They've got some specific duties to fulfill, and if they do those, then they've fulfilled those and they won't be on the hook for problems. Okay, so the COLP should have regard to any conditions, the standard ones, as well as anything that perhaps arises from any problems that have cropped up, or perhaps not problems, perhaps other risks through no fault of the firm that the SRA have decided to put some conditions on their authorisation as a result. COLP needs to know what these conditions are and promote, facilitate, monitor compliance with them. We'll look a bit more later on about what the COLP and COFA actually need to do. Okay, so thirdly and finally, the COLP has duties to facilitate and monitor compliance by the firm, the partners, the staff, and the owners of the firm with the statutory obligations imposed upon those persons. Now, interestingly, one of these statutory obligations includes a duty on law firms and staff to comply with all SRA rules and regulations. So that includes the accounts rules. So although the COFA is specifically said to have responsibility for the accounts rules, and at one point it's indicated that the COLP is not responsible for facilitating, etc., compliance with the accounts rules, this third limb does actually require them to take on the same role in that respect. I know that will sound very odd for anyone familiar with these requirements, because we always think of the COFA being the one responsible for the accounts rules, and that being the one thing the COLP's doesn't have any responsibilities for. But I think that's right. If anyone is as sad as me and wants to look at the detail, the statutory duty I'm thinking of comes from Section 176 of the Legal Services Act 2007. Again, a little bit more information in our free ebook on the website for those who are interested. Okay, so where does that take us then? Certainly quite a bit of overlap between the roles, more than perhaps appears at first glance. So the COLP and COFA, they need to work together, perhaps obvious in any event, but particularly important in terms of the overlap. I don't think the SRA is going to thank anyone for duplicated reports from the COLP and the COFA. That wouldn't make any sense. And I doubt very much either that they would want to see, duplicated compliance systems with two separate logs. COLP and COFA should agree between them who's going to do what, and when an issue arises, who's going to action what from there. Okay. Make sure that there's no duplication as well, because I just don't think it would be necessary. Okay, so we now know who's responsible for what areas of compliance. So let's have a look in a little bit more detail at what the COLP and the COFA have to actually do to fulfil the duties in their respective areas. Okay, firstly, as we looked at briefly before, the COLP and the COFA are there to help the firm and anyone involved in the firm to achieve compliance. Specific wording of the requirement is to take all reasonable steps to ensure compliance. Okay, and that's compliance in their relevant area. So for the COFA, it's going to be the accounts rules, although as we say there is some overlap. Now, when we talk about the COLP-COFA responsibilities for promoting, facilitating compliance, we're not just talking about the firm. We're talking about the partners or members in an LLP, directors in a company, etc., employees and owners of the firm. Now, as I said, that doesn't mean that staff responsibilities become the COLP-COFA responsibilities. They do not. Individuals very much retain personal responsibility for compliance. What it does mean, though, is that the COLP and COFA are expected to take certain steps to facilitate compliance by those persons, by the staff, by the firm. Okay. There's a little bit more information later in the talk and on our website about how that can be done. But some basic points here just to illustrate this for you. The SRA does clearly expect the compliance officer and the firm to set up some systems and controls which will help the firm, help the partners, employees, etc. to meet the requirements which apply to them. SRA does seem to accept that the steps which are actually taken to ensure compliance will very much depend upon the size of the firm and the nature of the work that the firm does. Sole practitioner, for example, not going to need the sort of systems that you would need in perhaps a large or international law firm. The most fundamental point to note about the duty to take all reasonable steps is that it is limited to just that. There's no strict liability for every breach which arises. The SRA has made that very clear. If a compliance officer has fulfilled their duties, but a problem arises nonetheless, they're not responsible in terms of that limit of the duty. They're not stepping in the shoes of the person who's made the error, despite their best efforts. Do take note, though, compliance officers, if you don't fulfil these duties, you can expect to be subject, potentially, to SRA investigation and sanction in the usual way, as for any other failure to meet regulatory requirements, if in appropriate circumstances, of course. Okay, secondly, COLP and COFA, they must keep a record of any instances of a failure to meet the SRA standards. Now, this presumably means not just the SRA requirements, but also legal requirements.